G'day, it's fugitive Australian journalist Shane Young from the website kangaroocourtofaustralia.com. Now, the ABC have filed their defence in relation to Bruce Lehrmann's defamation claim against them. And based on that defence, it looks like Bruce Lehrmann and his lawyers have given themselves an uppercut. And there's a very good chance the case will be thrown out on legal technicalities before it even gets to hearing. Because there's a couple issues there. Firstly, Bruce Lehrmann has filed a faulty concerns notice by the looks, and they'll get kicked out on that grounds alone. And secondly, if it wasn't kicked out on that grounds, there seems to be admission by Bruce Lehrmann that no serious harm was done. So that's the second ground it could be kicked out on. But we'll have a look at the first ground in a second. But just on the background, Bruce Lehrmann has filed numerous defamation lawsuits, firstly against Channel 10 and also News Corp, which he filed back in February. He needed an extension of time. He's been granted that extension of time because their defamation claims against them happened a couple of years ago, and you only allowed 12 months. So he was granted an extension of time. In relation to his defamation claim against ABC, he didn't need an extension of time because that related to Brittany Higgins giving a speech at the National Press Club in February last year, 2022, and he filed it just within the 12-month limit. But they've both filed under different laws. And the reason being the defamation laws only changed in the last 12, 18 months. And so with the new laws, he has to prove serious harm. And he not only has to prove that, he has to outline it in his concerns notice. Before you file a defamation claim now, you have to file a concerns notice. Previously, you're meant to, but no one did. But now they're a lot stricter on it, and it's actually outlined in the Act. And that concerns notice has to say, okay, I was defamed by this article or that TV show, etc. So, you need to give some details. And it also has to outline, okay, this is a serious harm. I lost my job, or it cost me $100,000. This is a serious harm caused. Or you have to outline the potential serious harm, the likely serious harm to be caused. I'll potentially lose my job. I'll potentially lose all this work, or etc. And when Bruce Lehrmann's lawyers sent the ABC their concerns notice, it didn't outline that. So in the Act, it says that if they send you a concerns notice and it doesn't outline the serious harm caused, you can send them a letter asking for further and better particulars. And they've got 14 days to respond, outlining what the further and better particulars of the serious harm is. They have to give better details. And if they don't do that, or if they do respond and it doesn't have the further better particulars in there, well, it's redundant. The concerns notice. And if you've got an invalid concerns notice and you file a claim against someone, well, the claim is invalid. And that's what the ABC are arguing in their response, in their defence. They're saying that the concerns notice didn't have the particulars of the serious harm. And when we wrote to them and they responded, they still didn't have further and better particulars. They didn't outline the serious harm. So it looks like it'll be kicked out on that grounds alone. Now, I'll read this section out verbatim. This is a part of ABC's response in relation to serious harm. And it says, if, as asserted in paragraph 10A of the statement of claim, it was notorious throughout Australia that Lehrmann was the person accused of and charged with the sexual assault of Miss Higgins. Now, what it looks like they've done, Bruce Lehrmann and his lawyers, have done, they've said, even though Brittany Higgins at the National Press Club didn't actually name Bruce Lehrmann, it was notorious throughout Australia that Lehrmann was the person accused of the alleged rape. So they're saying, well, that's how he was defamed, even though he wasn't named, because he was notorious throughout Australia. But what that does, it says, well, how can there be serious harm if it was notorious throughout Australia that he was a person accused of the rape? Well, the National Press Club couldn't have done any more harm. So there was no serious harm done by the National Press Club speech that Brittany Higgins gave. So they've given themselves an uppercut. They've actually, because it works like this, you've got to outline the serious harm in your concerns notice, then you file your claim at a later date, then you can have the judge just deal with the serious harm element. And even though you might have outlined in your concerns notice, you've still got to prove it. So you might ask the judge, look, there's no serious harm, Your Honour. let's deal with that part first. Can you make a judgment on that part first? Say without spending big dollars preparing for a trial. Well, if a judge was to do that, the ABC are going to argue, look, Your Honour, they've admitted it was already notorious throughout Australia that Bruce Lehrmann was the alleged rapist. Well, we obviously couldn't have done any more harm than that. So what's the old saying? Too smart by half. They really stuffed themselves. And the reality is it probably wasn't going to get the judge making a decision on serious harm because it's not in the concerns notice, the ABC is saying. And it's obvious why it isn't in the concerns notice, because it was notorious before the National Press Club hearing speech that Bruce Lehrmann was alleged rapist. So the speech at the National Press Club couldn't have done any more harm. Now, the ABC are running a number of defences, public interest defence. They're using the Longy defence, which is a political communication defence, which is qualified privilege, both legislative and also common law they're going to be using based on their response. But they're not using the truth defence for some reason. The Channel 10 and the News Corp are using the truth defence, and so is Lisa Wilkinson. She's got lawyered up. She's got her own barrister. So they're all using the truth defence, but the ABC aren't for some reason. But probably not going to matter because I doubt it'll get to that stage anyhow, because I think it'll be kicked out on the concerns notice issue. I advised someone recently in the concerns notice issue. I represented myself numerous times in relation to slap lawsuits, defamation lawsuits by Kerry Stokes and his associated companies. But that was under the old Act with updates. I doubt Kerry Stokes would have ever gotten away with filing claims against me because he would have had to prove serious harm right up the front in the concerns notice. And I think this matter is going to be kicked out on that exact ground. And the person I was advising on that issue, she ended up lawyering up. I advised her to try and get a pro bono barrister, and she did. And it was kicked out on the grounds that the concerns notice didn't identify any serious harm. And for that to happen, I suspect that once it gets back to court, the ABC will file the claim to have it set down, to have it kicked out on the fact that Bruce Lehrmann's claim is defective because the concerns notice is defective. And the judges to date have been very stringent on that, and so they should, because it's actually outlined in the Act specifically. The concerns notice has to be served on the other party, and it has to have this, and it has to have that, etc. And obviously, I'll keep on following up on this issue. And Kangaroo Court of Australia is independent media, so relying on donations to keep on publishing. So please support my Patreon account or PayPal account, and please share this video on Facebook and Twitter, etc. Thank you for your time, and have a good day.